afternoon, salam alaikum. My name is Leddy. I'm head of litigation at Legal Action Worldwide. We're a global nonprofit based in Switzerland that does litigation and advocacy on behalf of victims and survivors of human rights violations and international crimes. What sets us apart from other organizations is that we have offices in the field serving the survivors and clients that we represent in these proceedings. So we have an office here in Nairobi. Some of our staff are here today. Say hello to Ivy and Joan if you have a minute. But also we have offices in Beirut, in Kyiv, in Cox's Bazar, in Bangladesh, in Sri Lanka, and Colombo, as well as in New York. So we're a global organization with programs around the world. I'm going to talk a little bit today about our Sudan program, which I'm very excited to discuss, as well as a few examples of how we've been able to disrupt criminal activity through litigation in other contexts. So to start, we're an organization that uses a survivor-centered, trauma-informed, gender-sensitive lens to our investigations and our litigation. What does that mean in practice? That means we look at different intersecting grounds of discrimination in crimes, whether it's on the basis of race, ethnicity, gender, or age. We also make sure to incorporate a trauma-informed approach in the sense that we do no harm to our clients, make sure that we have active referral pathways for psychosocial referrals before interviews, during interviews, and after them, and certainly when engaging with survivors in litigation. We also do a lot of work around litigation in domestic, regional, and international mechanisms, and I'll talk about a few of those examples today. But what we really start with is, what do survivors want? What do our clients want? What does justice mean to them? For example, we did an extensive analysis in the Rohingya context about what justice means to them. And we interviewed, I think it was 400 or so Rohingya survivors who really talked about justice to them having been effectively deported into Bangladesh after experiencing a genocide in Myanmar. Justice to them wasn't a criminal trial. It wasn't a conviction. It was getting their land back. It was going back to their home and having citizenship and having rights. So to them, you know, we often think in this international justice world about trials and convictions and what does that mean, but I think we really need to start with survivors and asking them what's important to them. What does justice mean to you? And so that certainly informs our litigation strategy and what kind of forum we seek to engage with, whether it's civil or criminal litigation or reparations or other. So I'll just give a few examples then of what we've done on behalf of clients in different contexts. But first, actually, sorry, I'm going to get into the Sudan program, of course. So we started a Sudan program last year. We have one of our partners here, SIHA. I know there's a representative from SIHA here. I believe she was. Yes, where's Safa? There she is. Hi, Safa. And thrilled to partner with SIHA and our work on behalf of women and girl survivors from Sudan through the office in Adre in Chad. But the goal is to provide legal services, including legal advice and information to survivors of gender-based violence, but also to engage in strategic litigation on their behalf. We hope to replicate a program that we have in the Rohingya community, whereby we've empowered over 60 survivor advocates to become advocates within their own communities, informing about justice opportunities, about what international justice mechanisms look like, how they can participate in those processes, and really a kind of grassroots, community-led justice model. So we're hoping to replicate that soon in Adre and looking forward to that success. But also, like I mentioned, there's a strategic litigation component as well, and we're looking to file cases on behalf of those survivors in Adre as well as others in Sudan. And I know we've been in touch with some of the groups I see here today, including Satil Banat and others, about potentially collaborating in that regard. So great to be in touch. And certainly want to collaborate further. So a few examples of how we've done this in other contexts. I'll talk quickly about, in Myanmar, you heard me talk about our Rohingya program. We filed a case, we participated in a case in Argentina. It was filed by a local lawyer, an Argentine lawyer, Thomas Quintana, as well as a Rohingya rights organization called Brook. And they filed the case a few years ago alleging genocide and crimes against humanity. And we were brought in, we had 7 clients testify in that proceeding 2 years ago. So I went down there to Buenos Aires with them to prepare their testimony. And indeed, just a few weeks ago, we had a great result whereby the local judge ordered arrest warrants for over 20 senior Myanmar officials for these crimes. So that was a big win for the survivors, a big win for the case. It remains to be seen when and if these officials will be arrested. But it's important to note that Argentina has a rich legal regime whereby it has extradition agreements with lots of countries. It's a signatory to the Hague, the Ljubljana Convention, whereby I think it's 36 states have agreed to extradite perpetrators of serious international crimes should they be arrested on their territory. So that immediately means that those 20 plus officials can't travel to these countries, and that importantly it's also a sign to survivors that courts hear them, they recognize their voices, they're honoring their experience and confirming that indeed there's a chance these crimes happen and that accountability is important. So a big win in that regard. Another one I can talk about is our case before the African Commission of Human and People's Rights that we've done with Palu. I think Don Diaz might be here. There's Don. Hey, Don. With Palu and a law firm in New York, Debevoise and Plimpton. We filed a few years ago on behalf of Tigrayan survivors alleging serious breaches of the Banjul Charter. And this was against the state of Ethiopia, of course, for crimes and violations that were committed in association with the conflict from 2020 to 2022. In that context, we were able to achieve provisional measures, so measures ordered against the state of Ethiopia to cease violations, including gender-based violence, and to unblock the humanitarian aid, which they had prevented from reaching Tigray. But also, importantly, assigned to our survivors again that there are remedies available. If domestic courts are not, we can look at regional bodies for relief. So that case is ongoing, hopefully going to the merits this year. The other example I wanted to mention quickly was a case before CEDAW, the committee in Geneva for the elimination of discrimination against women. This is on behalf of 35 South Sudanese women, victims of CRSV, of conflict-related sexual violence. We were able to obtain a victory of first, as I understand, in the treaty body system to protect their identities from the state. Initially, we were rejected multiple times incorrectly for being an anonymous complaint, even though we had the names. We just didn't want to give them to the state that was committing the crimes against these very women. So in the end, after many years of litigation, we're able to achieve that result for our clients. And to the theme of this panel, finding a different way to disrupt this criminal activity, whether it's through regional human rights treaty bodies or regional organizations or domestic courts. So I just wanted to end with another tactic that we're kind of exploring now, which is disrupting the financial flows of these perpetrator groups and individuals who might have proceeds from crime or obtained ill-gotten goods. And we're looking, as part of our universal jurisdiction, mapping different laws in the countries of interest, including Kenya, Uganda, Mauritius. These countries all have laws on the books that allow for civil forfeiture. So if there's not a criminal case, we could bring a case civilly, perhaps prior to bringing a criminal case, whereby someone's assets are identified, frozen, because they're the proceeds of crime, whether it's, I heard earlier about the trading in gold or weapons or otherwise, but certainly something we're interested in exploring more as it relates to the interests of our clients and our victims who are victims of international crimes. And the note I wanted to end on was just a word of inspiration that an old colleague and now judge at the ICC, Betty Holler, always said, and Poubadou knows this well, is that she always believed the future of international criminal law is domestic. And that resonated with me, hearing her say that for years. And now I think that's really true, that this is the moment where certainly there's a huge role for the ICC to play in this ecosystem, but that if we want to end impunity, we have to use domestic courts. We have to exercise every avenue we can in the interests of our clients, in particular using universal jurisdiction where possible, to make sure that we do whatever we can to close the impunity gap. So I'll stop there and